begin shortly. Please remain on the line.
*1, and then hang up the phone. It says click on start.
The webinar will begin shortly. Please remain on the line. *1.
The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. Welcome to SECAF's webinar about the new and expanded Small Business Mentor-Protégé program. My name is Shiv Krishnan. I am a SECAF board member and president of Indus Corporation, a Tetra Tech company. I've been involved with SECAF since its inception in 2001. First, let me provide some guidelines regarding this webinar to help you. Each of you should have a small control panel in the upper right-hand corner of your screen. All participants are muted, but you may ask a question at any time by typing it into the questions box. If we have time at the end of the webinar to answer some questions, we will. If not, we will make sure that we review all the questions and respond to you after the webinar. Below the questions box, you will also see handouts. We have provided the PowerPoint presentation to you so that you may print it, follow along, and make notes if you like. This afternoon, we will also send you an email asking for your feedback. Please do take a few minutes to answer a brief survey that will help us make this webinar better as we move forward. This email will also include a link to the recording of today's webinar. For SECAF members, we will post this webinar for your future references on the SECAF website, accessible to members only. If you are not a member of SECAF, please do visit our website at www.secaf.org for more information about membership and to join online. Let me give a quick brief overview of SECAF for those of you who do not know about us. SECAF is focused on the small and emerging government contractors. Our objectives are to educate, empower, and enable growth for the small and emerging government contractors. We bring key government and industry leaders to interact with our member companies to help level the playing field, because we know our small business member companies are always trying to efficiently manage their scarce resources. This webinar series is an increasing part of SECAF's national outreach to bring the best of our government and industry resources to benefit small government contractors throughout the country. I'm pleased that we have participants from several states around the country today. I'm pleased to introduce to you my colleague and good friend, Devin Hewitt. Devin has been incredibly active on the board of SECAF and also serves as the chair of our Legislative and Government Affairs Committee. Devin will be presenting today's webinar. Devin is a partner at Mentor-Protégé Law, PLLC, and has over 20 years of experience in the field of government contracts, representing small, mid-tier, and large government contractors. She advises clients on a wide range of government contracting issues, including FAR compliance, small business contracting programs, intellectual property and data rights, GSA schedule, the Service Contract Act, non-compete, non-solicitation, and non-disclosure agreements, subcontracts and teaming arrangements, joint ventures, FOIA requests, due diligence and novations of contracts, contract claims, codes of ethics and business conduct, mandatory and voluntary disclosures, suspension and debarment, terminations, and government audits and investigations. All of these topics are very critical for any government contractor, and especially the small and emerging government contractor, because we are all subject to these rules and regulations in doing our business. As entrepreneurs, we all know that growing our business to deliver the best value to our customers is easier said than done. We fight the battles every single day. Along the way, we need to surround ourselves with the best people with the most experience to help us build our companies. With government regulations changing all the time, it is critical to keep on top of what the current state of the small business regulations are, to understand how they impact our business, both in terms of helping it grow and also sometimes adversely impact our business. Devin is no stranger to SECAF, and please do join me in welcoming Devin for today's webinar. Devin?
Thank you, Shiv. Today we're going to talk about the new regulations that were issued covering a new small business mentor-protege program. The new regulations implement provisions from the Small Business Jobs Act of 2010 and the National Defense Authorization Act for fiscal year 2013. So these have been long-awaited rules. The rule was published July 25th, 2016, and became effective on August 24th, 2016. SBA received 113 comments in response to the proposed rule. Now, the rule covers the Small Business Mentor-Protege program, but in conjunction with the new rule for this program, there are new rules also published for joint ventures, new rules published for the Section 8A program, and just a few new rules for the hub zone regulations. Now, with respect to the Small Business Mentor-Protege program, SBA was supposed to begin accepting applications on October 1st, 2016, but on October 1st, 2016, the websites included a message saying that interested parties who wanted to submit an application during October could request a hard copy application by sending a message to SBA, and that they would start accepting electronic applications, in fact, as of November 1st. So they aren't quite up to speed just yet. Now, this new Mentor-Protege program is distinct from, although somewhat related to, the Section 8A Mentor-Protege program. As I mentioned, they have similar requirements. For example, the mentor still has to provide tangible financial, technical, or management assistance to the protege. And by tangible assistance, for example, financial assistance can include equity investments or loans or bonding help. Technical assistance can include various aspects of trade education or assistance in achieving certain certifications, whether it's ISO or CMMI certifications. Management assistance is a little bit broader. It can include, and almost always does include, business development assistance. Sometimes it can include assistance with regarding to establishing certain internal control systems or accounting systems. So there's a variety of types of assistance that can be provided. In addition, like the Section 8A program, the mentor may own up to 40% of the protege. And this program, importantly, also permits joint ventures between small and other than small firms and allows an exemption for affiliation for those arrangements. This Small Business Mentor-Protégé program is going to be open to all types of small businesses, including SDVOSBs, WOSBs, HUB zone concerns, and also it's open to 8A concerns too, although they have a separate mentorship program that they can take advantage of. The application process will start with an electronic application that is supposed to be, as I mentioned, up and running by October 1st. It's going to be up and running supposedly by November 1st. And that process starts at going to a website link called certify.sba.gov. It's all going to be electronic. There's not going to be any requirement for what they call wet signatures. The applications will actually be processed by a unit within SBA's Office of Business Development, which is the office that also handles 8A applications. Initially, commenters were worried about what they anticipated to be a massive influx of applications and weren't sure that SBA could handle it. But SBA says that they can handle it. They've established this unit. And initially, they're not going to have open or closed periods for applications like GSA does. Instead, they're going to go ahead and accept them as they come in. But they reserve the right to do an open and closed period if it turns out they do have an unexpected amount of applications. Before submitting an electronic application, both the mentor or prospective mentor and protege must register in SAM, and both the mentor and protege must complete online training available through SBA's website before submitting the application documents. If SBA denies an application, a request for reconsideration must be filed within 45 days. And then SBA is supposed to issue its decision on that application or reconsideration application within 45 days. Now, during that point in time for reconsideration, the parties can revise the mentor-protege agreement to address the concerns that came out in the initial denial. So hopefully there is an ability to go back and forth with SBA to get an agreement that satisfies SBA and the regulations. If the final reconsideration decision raises new grounds that are independent from the grounds that were raised initially, the 45-day period starts over. Now, if SBA ultimately denies the application, the protege must wait 60 days before submitting another application with the same mentor. However, they can submit an application with a new mentor at any time. Now, in terms of mentors, the mentors must be a for-profit entity, which is different than what was previously the case for the SBA 8A program, but now this applies to both programs. Mentors can actually be of any size, although they are typically other than small businesses, but they don't need to be. The mentor has to have good character and must not be suspended or debarred. The financial capacity factor now is a little bit more flexible. Initially, they had to demonstrate good financial condition, which can be a subjective assessment. Now the mentor only needs to show financial capacity to fulfill the mentor-protege agreement obligations. And in order to evidence that, they can submit copies of federal tax returns, audited financial statements, or publicly traded SEC filings. And actually, this type of evidence was the type of evidence that a mentor had to submit for the 8A program as well. So that really isn't that great a difference. A mentor may only have 3 proteges at one time, and that's the maximum. And these 3 protege agreements have to be across the 2 programs. They're not individually for each program. And in making the application for a second or a third mentor-protege agreement, the mentor must show that the multiple or a second or third agreement won't hinder the development of any one protege or the former protege. And in this regard, what SBA is going to be looking for is to make sure that the proteges aren't competitors, or aren't in particularly the same NAICS code, to ensure that the type of assistance that's being provided by the mentor under different types of relationships is different. If a mentor experiences a change of control, after that change the mentor has to recommit and express in writing to SBA its acknowledgement of the mentor-protege agreement and its willingness to continue by its terms. And the mentor can also be a protege. With regard to proteges, the protege must be small under the size standard associated with its primary NAICS code. Now this is a big change. Previously under the 8A program, the protege had to be either in the developmental stage of the 8A program or never have received an 8A contract, and its size had to be less than half of its primary NAICS code. So that eliminated those complications. All that's important is that the company is small under its primary NAICS code. Now, the protege can get a mentor-protege agreement in a secondary NAICS code if it shows that it was no longer small under the primary NAICS code, but it has gotten experience and increased number of revenues doing work under a secondary NAICS code. And that the mentor-protege agreement and moving to a secondary NAICS code is a logical business progression for the company. A protege may have up to 2 mentors. SBA will only approve the second mentor-protege agreement if the relationship is under a different NAICS code or different types of assistance is being provided. And so what SBA is looking for is to see that there's specific expertise that is being provided in the second mentor-protege relationship that either is not being provided or is no longer being provided in the first relationship. A protege may serve as a mentor, and while applicants self-certify, unlike the SBA 8A program where you have to go through a admission, eligibility, and assessment review, SBA may actually go ahead and do this review on SBVOSB and WOSB certifications. With respect to the mentor-protege agreement, the agreement must be in writing, and it must detail the specific assistance with a timeline to be provided to the protege. And in this regard, the SBA is really looking for specifics. They want to see that the assistance meets the protege's needs. Now this is a little difficult because in the 8A program, what you used as the guideline was the 8A's business plan, which identified what the needs were and what it looked for to grow in the SBA 8A program. You're not going to have this existing document that outlines the needs, so that will have to be part of the application package. There's going to be a minimum of a 1-year commitment between the mentor and the protege to this agreement. After that, the agreement can be terminated upon 30 days advance notice, but the agreement can extend up to 3 years, and then it may be extended for an additional 3 years. So you could have a mentor-protege for a total of 6 years. However, the SBA may terminate the mentor-protege agreement at any time for a number and variety of reasons, some of which we'll discuss later in this webinar. In the application process, the mentor must identify, or the mentor and protege must identify other mentor-protege relationships and then talk about the difference in between the two and the different expertise and assistance that would be provided under the second or third mentor-protege relationship. And there's got to be a single point of contact identified for the mentor in the actual application. And finally, any changes to the mentor-protege agreement must be approved by SBA. One of the negatives, if you will, of this mentor-protege program, which is also true of the 8A program, is that there are numerous reporting obligations that the parties have to satisfy at various points in time of their relationship. Within 1 year of the anniversary date of the mentor-protege agreement, the protege has to provide an exhaustive report to SBA. And this report would include all the subcontracts that have been issued between the parties, all federal contracts awarded if a joint venture had been created and received awards, and also a narrative describing the success that the protege has realized as a result of the assistance it has received from the mentor. The report has to include specifics regarding the nature and quantity of the assistance provided by the mentor, and that means identifying the specific type of assistance and the specific time of assistance. For example, whether there were meetings on a quarterly basis, how many hours the meetings were, with whom the meetings conducted, the subject of the meetings, and associated time elements. So it gets down to a very granular level. Now, what's new in this particular program, and is going to be across both programs, is an annual certification from the protege that the mentor-protege agreement has not changed. And the mentor-protege agreement's validity, it depends on SBA's review of these documents and reports on an annual basis. So it's subject to SBA approval. Now, if SBA has reason for disapproving the continuance of a mentor-protege relationship, they will first notify the mentor and allow it to respond to SBA's concerns. However, if the concern doesn't respond, or somehow the response is inadequate and doesn't satisfy SBA's concerns, SBA may terminate the relationship, and the mentor cannot be a mentor again for 2 years. The SBA may also request the agency to issue stop work orders on any joint venture contracts the two parties may hold. And in that event, depending on the capacity of the protege, SBA may recommend that the protege be substituted as the contractor in that instance. And depending on the egregiousness of the issues that SBA has found in its annual review, there is a possibility for suspension and debarment proceedings to be initiated by SBA. As an aside, the rule allows now an 8A to transfer its 8A mentor-protege relationship to the Small Business Mentor-Protege program upon graduation from the 8A program. And they don't have to go through a new application process. All they need to do is provide some notice to SBA that they want to continue in the Small Business Mentor-Protege program. And because there's this ability now to transfer or enter into the Small Business Mentor-Protege program, the SBA now has limited the provision that previously had prohibited an 8A concern from applying to the Mentor-Protege 8A program if within its 6 months of program graduation. With respect to other agency mentor-protege programs, other programs may continue for 1 year. After that 1 year period, they have to get the program approved by SBA. The only exception to this rule to date is the DoD mentor-protege program and the SBIR STTR program. Now, the DoD program, as an aside, on September 23rd issued new proposed rules for that program, which includes additional requirements for proteges, and it's just more expansive and somewhat more in line with the SBA's program. Now, there were many comments on this aspect of the proposed rule, and in particular, the commenters were concerned that other agency programs provided certain incentives that weren't provided under the 8A program and maybe were not going to be contemplated under the new SBA Small Business Mentor-Protege program. And those incentives had to do with subcontracting assistance that the mentor would provide the protege in those other programs. In particular, agencies would award evaluation points if the mentor was using the protege as a subcontractor on an unrestricted contract award, or the agency would allow additional credit under a subcontracting plan when the protege was going to be used as the subcontractor. So with the possible elimination of other agency mentor-protege programs because of this now small business-wide mentor-protege programs, commenters were concerned that those type of incentives would no longer be available. SBA has responded to that, recognized our different incentives, and now authorizes federal agencies to use those incentives as they would like in connection with this new small business mentor-protege program. There are now uniform provisions for joint ventures across both programs. What's most important is that the joint venture relationship must be reduced to a written agreement. The SBA rules contemplate that this relationship, even though it's a written agreement, may be informal, a partnership, for example, or be a formal relationship where there's a separate legal entity, and typically those are limited liability companies. One big change, though, is that SBA is no longer allowing for unpopulated joint ventures. Previously, you were able to have the joint venture itself employ the employees that were doing the work. SBA has reconsidered that because they feel that that doesn't allow the small business partner to actually experience and derive the assistance from the protege relationship that it otherwise would do if it was an unpopulated joint venture. Now, that doesn't mean that you can't have a few administrative employees associated with the joint venture. For example, a facility clearance officer or a program manager who's otherwise not 100% dedicated to the contract work. Now, if it is a separate legal entity, the protege must own 51% of the entity, and the profits have to be distributed according to ownership interests. However, if you think about it, this joint venture entity is really going to be a pass-through because the work will be being performed by the two partners, the large business and the small business. So really, the profits that are associated with the work are really going to go through the joint venture entity and go straight to the two partners. So the 51% allocation is really not going to result in additional profits going to either of the parties. Now, a joint venture has to be separately identified in SAM for tracking purposes. And this means that you need to have a separate DUNS number and cage code associated with the joint venture. The entity type has to be identified as a joint venture, and it must actually list the members of the joint venture in SAM. The written agreement has to include specifics, and this has always been the case for the 8A program. In particular, the agreement has to specify the facilities, equipment, and other resources that the parties are bringing to the relationship and to a particular contract. This was difficult, however, where there was an IDIQ contract because going into it, many parties weren't aware of the actual task orders that would be issued and exactly how the allocation of resources, equipment, or facilities would occur until the task order is actually issued. Luckily, in this rule, there's a recognition of that fact by SBA, and all they require are some more generalities regarding how the allocation of resources is going to occur. Well, what I typically advise clients in this situation is to look to see how the allocation is described in the proposal and use that as an example, or if there's been a task order, sample task order, or a specific task order associated with the IDIQ, look to your solution for that and describe that generally and indicate it may not be the exact solution, but this is how the parties are contemplating the various resources and allocations to be. Now, the protege must perform 40% of the work, and that is the same standard that is for the 8A program. What's new now is that the project manager can be a contingent employee. Previously, the project manager had to be an employee of the protege, But again, many project managers are only going to be hired if a contract award actually occurs. And so SBA recognizes that and says that as long as there's a letter of commitment that the project manager has to the award, that suffices. Now, the project manager, however, cannot be a current employee of the mentor, because the expectation is that that employee would probably go to the protege for the term of the contract and then go back to the mentor, and that's not what's contemplated in terms of the long-term assistance and growth of the protege. One of the biggest and most important changes in this rule, in my view, was a mandate that the past performance of JV members must be considered by the agency in assessing the past performance of the joint venture itself. This is huge because a lot of joint ventures really couldn't compete on solicitations because the agency required the past performance to be associated with the joint venture itself. And since joint ventures are generally specific purpose entities and are created for a particular opportunity, this pretty much meant that the joint venture really couldn't compete because it couldn't get the past performance credit that it needed for that particular procurement. Another clarification that came out of this rule was that these joint ventures, including 8A joint ventures, are still subject to size protests. There was a belief that was evidenced in an Office of Hearings and Appeals case that because SBA had approved an 8A joint venture, that implicit in that approval was the size of the joint venture being compliant with what the applicable NACE code size standard was. But they've clarified now that no, that all types of joint ventures can be subject to size protests.
Devin, it looks like joint ventures is a huge benefit to these small businesses that can partner with the large businesses, and they can also benefit from the past performance of the large business mentor to be used in gaining more experience, winning contracts, and then having their own employees participate in the JVs.
Correct. It's interesting. Often I'm asked, what is the advantage for the protege? Because sometimes the assistance that's coming through they may not necessarily need. But really the biggest advantage of the protege of entering these joint ventures is the ability to compete for larger set-asides that otherwise they couldn't compete individually by themselves. And one of the big issues is past performance. The breadth and the timing of past performance is very important in remaining to be competitive. With respect to these joint ventures, only 8A contracts require prior SBA approval of the joint venture agreement, and this approval only needs to be accomplished before contract award. However, the 8A joint venture can submit the agreement for approval at any time. It's just unlikely that SBA, depending on its workload, that will take a look at it until the SBA is sure that there's a likelihood that there's going to be a need for this joint venture agreement to be approved. A new clarification now in the rule is that hub zone firms may form a joint venture with other non-hub zone firms. Previously, they had to be with other hub zone firms. However, the protege cannot rely on the mentor employees to satisfy the 35% hub zone residency or its principal office requirement. That remains to be evaluated solely on the hub zone itself. Just like there are a number of reporting obligations associated with the mentor-protege agreement, there are also reporting obligations associated with joint ventures. And these reporting obligations are going to apply to all types of joint ventures. In particular, the rule describes them as certificates of compliance. And prior to each set-aside contract or a contract with reserve, each member to the joint venture has to submit the certificate which states that the JV fully complies with regulatory requirements, that the JV will perform the contract in compliance with the JV agreement, and that the JV will perform the contract in compliance with the performance of work requirements. And the performance of work requirements refers principally to the performance of work requirements associated with the FAR clause limitations on subcontracting. And so that's an important consideration in these certificates of compliance. There's also a secondary performance of work requirement, and that has to do with the 40% work share that the protege has to perform during the joint venture agreement. Every year there has to be a report that details the compliance with the performance of work requirements that's submitted. And then another certificate of competency must be submitted at the completion of a contract. And again, this certificate has to detail how the performance of work requirements were met and certifies that they were met and certifies that the contract was performance in compliance with the J regulatory requirements. Failure to submit this certificate of competency may be grounds for suspension or debarment. Essentially, what SBA is doing here is transferring the burden of proof or the risk, for example, associated with compliance with these regulations to the contractor who actually has to submit a certification, which is a serious representation that, if false or fraudulent, can lead to criminal penalties. That's it for the SBA Small Business Mentor-Protégé program. But along with this program are changes to the 8A program, some of which relate to the Mentor-Protégé program and some with which are just cleanup items that SBA has chosen to publish at this time. One example of this is that there need to be more specifics required for demonstrating social disadvantage for those applicants that need to demonstrate social disadvantage. And what SBA has emphasized in this rule is that they're not raising the standard, which is still preponderance of the evidence, but what they are looking for is in the narrative to flesh out more facts. So for example, rather than saying you've been discriminated against because you're a woman and a man has received a promotion, what you need to flesh out is the fact that both of you had similar qualifications and background and experience, and that in that event he was promoted over the woman. So it was those extra additional facts that add color to the context of the situation, which makes it more likely than not that discrimination was the cause of the event. Another change is that the management experience by an 8A owner doesn't have to actually relate to the concern's primary NACE code. Typically, when SBA is assessing control of a concern and wants to make sure that the actual individual on which status is based has the ability to actually run the company, and that usually looks to some sort of experience in business and management experience. But what they've clarified now is that it doesn't actually have to relate directly to the industry as long as there's been other basis for management experience in the past of this particular individual. Previously, applications could have been filed paper-wise and sent by mail. Now they have to be filed electronically. Again, there's no requirement for a wet signature. You can have an electronic signature. Now SBA has discretion where the SBA application identifies criminal conduct. Before, the SBA had to refer the application to the SBAIG to look over the possible criminal conduct and make a review and assessment about whether or not the applicant was eligible for the 8A program. Now SBA has discretion to look at something and say, oh, it's 20 years old, or it was, made just a disruption rather than a felony, and they can discriminate against what they really think affects the character and the integrity of the applicant. Narrative statements supporting economic disadvantage are no longer necessary. SBA clarifies that all they're going to look at are actually the numbers, the assets, and the revenues of the particular applicant, so there's no need to codify that in any type of writing. In this rule, SBA says that they actually may change the 8A's concerns primary industry classification on their own. What they're going to be looking at is the business plan and the source of revenues to see in the past 3 years if the revenues have evolved from stemming from one NAICE code size standard to another NAICE code, and in which case they might initiate this sort of change in the primary industry classification. SBA does state in the rule that they won't do this sua sponte on their own without any sort of discussion with the 8A concern, and explanations may be provided with the 8A concern indicating, for example, that a NAICE code was improperly assigned to a particular contract, or that they've got pending bids and proposals due in another NAICE code, which really, although it hasn't been realized yet, if realized, may account for the majority of their revenues. So there is an opportunity for the concern to actually participate in this process with SBA. SBA also now has authorized 2 additional instances where an SBA 8A program participant could suspend its participation in the 9-year term to account for some unusual circumstances. One of those now is where the principal office is located in an area that's declared to be a major disaster area, and also when there's a lapse in federal appropriations. And the reason for this, should be obvious, is during these periods of time, really no contracts can be awarded to the 8A, and there's unfairness if the program term keeps running when this period of time could be significant and may affect their ability to get the full business development assistance that they are entitled to under the program. There are a few HUD zone program changes. One important one had to do with SBA making a decision on a HUD zone application. What SBA now says is they will try to make a decision on the application within 90 days, quote unquote, whenever practicable. Previously had been a shorter turnaround, so that extended the turnaround. SBA reserves the information, however, to ask for information supplementing the application at any time. They reiterate that the burden of proof in an application is on the applicant, and so if certain documentation or responses are not provided, SBA is able to take what they call an adverse inference from the missing information. And the rule clarifies that the applicant must be eligible for program participation not only on the date it submits its application, but also up until the date that SBA issues a decision.
Devin, this has been amazing. Your command of this complex new rules and regulations is just amazing, and we are lucky to have you talk to the SECAF community to explain the new program and all of its benefits. We've been receiving several questions. Let me quickly go through a few of them. We have another 15 plus minutes. The first one relates to the joint venture. Does the new rule allow a joint venture between a large prime and an economically disadvantaged woman-owned small business classified company to use past performance of the large prime similar to the current 8A program? And also, is the JV classified as a small EDWOSB under the new rule?
The answer is yes. What's not set out in this particular question is assuming, of course, that the 2 companies are applicants and have been approved to be in the Mentor-Protégé program.
Okay.
That is a prerequisite to any joint venture with a large prime, because without that you can't get the exception for affiliation.
Okay.
So the answers would be yes, provided, of course, that the large prime and the EDWOSB are a mentor and a protege.
That's good. Thank you. What are some examples, suggestions on how to show SBA that a protege under the new regulations will not be harmed by a pre-existing 8A protege relationship under the 8A Mentor-Protégé program?
This is a good question, because it's not entirely clear what type of information SBA will accept. And I will say, having actually gone through this process with the client, that SBA takes a very strict view and normally will not encourage a second mentor-protege relationship. in that situation, what we tried to show was first that the two relationships didn't provide the same assistance. Also to show that they weren't, the assistance wasn't being provided under the same NACE code. There might be a geographical difference in terms of where the focus might be. So those are some of the things you can consider, but there's no hard and fast rule. You really do have to look at the differences between the two relationships and what the specific needs of the protege are to make sure that they're not duplicative in the two relationships.
Okay. One more question on JVs. This looks like the joint ventures have a lot of questions coming out. For unpopulated joint ventures, which seems to be coming out of the new regulations, who has privity of contract, and how can the mentor and protege companies cite the experience for past performance requirements once a contract is awarded?
Okay, the first question is the privity of contract goes directly to the joint venture itself because the joint venture is a legal entity. Now the better question though is, as a practical matter, who is actually communicating with the government? And since in joint venture agreements, the program manager and the the small member of the protege of the JV agreement has to control, that really should be the point of contact with the agency. So as a legal matter, privity of contract is with the joint venture. Okay. As a practical matter, the communications and the relationship between the agency and the joint venture should be through the small business member of the joint venture.
Okay.
And the second question had to do with, if you could repeat it.
Who has who can cite the past performance experience on that? Because it is a joint venture that is unpopulated, 60% of the work can be performed by the mentor and 40% by the protege under the existing rules. Mm-hmm. But does the protege cite that as a prime contract past performance, or does the mentor cite that as a past performance because they're doing the majority of the work? It can be very critical for the small business because if they cannot use this to cite as a past performance, then that is not going to help them.
Well, technically speaking, both parties should be able to cite the joint venture performance as their past performance. What we see, though, often with agencies is that in doing so, an agency may actually look to see that the small business, if it's citing the joint venture past performance, that the small business actually did the work that was part of the joint venture experience. So that doesn't mean that the small business can cite the past performance of the joint venture, but cite to work that only the large business itself did. Okay. So it can cite to the past performance work it itself did under the joint venture, but not necessarily the past performance of the work of all the joint venture.
Okay, so that'll be beneficial. One question on 8A joint ventures. You mentioned that 8A joint ventures require prior approval by SBA before they can bid on contracts. However, can an 8A joint venture bid on a contract while the application is still pending with SBA prior to approval and expect that SBA will approve it once the contract is awarded?
I think the answer is yes. Let me go over it. The approval occurs by SBA prior to contract award. After there's been an approval of a mentor-protege relationship, that has to occur first.
Right.
Parties can submit a joint venture application even though it hasn't been approved by SBA yet.
Right. Mm-hmm.
Does that answer the question?
No, that answers the question of, yes, the application has been there with the SBA, but because SBA is backlogged, they may not approve the joint venture for the 8A Mentor-Protégé. In the meantime, a contract bid RFP comes in, mm-hmm. and the joint venture, because it is a properly formed joint venture under the SBA approval, can go ahead and submit the bid because ultimately it becomes an 8A contract only if SBA approves and accepts it in the program.
Right. SBA doesn't have to approve it in order to submit the bid.
Okay, good. That was the question. That's very beneficial because some of these companies that are out there, they may be waiting for SBA approval. In the meantime, the contract opportunity is lost, and that is one of the things that they need to include in their application. A question comes in related to the DoD program. DoD has a draft language on their program that does not seem to be as open, particularly for plain small business. If primary work is with DoD and we are only small, how do we determine if we qualify, particularly regarding CAS reporting? I'm not sure if we are subject to CAS reporting under our 2 subcontracts.
Well, usually small businesses are not subject to CAS. And I think that there's one type of protege that is associated in the DoD program associated with the CAS, but typically small businesses are not subject to CAS.
Yeah. Thank you. This one seems like a pretty straightforward question. Is a joint venture required for participation in the program, or is it optional?
It's optional. It's one of always the big advantages for large mentors, which is one of the reasons they're willing to provide all the assistance. But if a mentor is willing to provide all the assistance without the benefits of a joint venture, or for example, owning 40% of an entity, they can do that as well.
Another SBA related question. Does the SBA use the same method to determine size standards within a given NAICS for a joint venture average of last 3 years of revenue?
Yes, but the issue that is probably going to come up in joint venture world for size is not the issue of revenues, because as we've talked about, most of these joint ventures aren't already existing and already have a past performance history. The way it's going to come up is that somebody is going to allege that the mentor and the protege are actually affiliated because the mentor-protege agreement or the joint venture agreement is not valid, or there's some deficiency in it. So that's how that size protest would take shape.
And also because the joint venture itself is an unpopulated joint venture, the technical legal entity exists. However, the revenues accrue to the mentor and the protege who are actually doing the work.
Yes, it's a little unclear because, for example, for limitations on subcontracting purposes, the revenues accrue to the joint venture because that's what you have to do for allocations. So it depends on the instance of the analysis.
Okay. Some interesting twists over there. For your clients who are firms that currently are mentors under 8A program, what are you recommending when they ask how they should approach attempting to mentor a second firm under the small business program?
Well, the big issue, as we've discussed, is whether or not that second relationship is going to be duplicative, or if you're looking for another protege, whether or not you have the financial capacity to be able to hold more than one mentor-protege agreement. So I don't know if the question had to do with what whether having the same protege, or whether this was an agreement where a mentor had different proteges.
Mentor had different proteges is how I'm reading it.
Well, then that's only a financial capacity question by the mentor and its ability to provide assistance to another protege.
Yeah, the mentor can have up to 3 proteges, you said, and I guess the question looks like it's related to how can you have a second firm under the small business program approved if you already have one with the 8A Mentor-Protégé program.
Yeah, let me supplement that by saying that not only is it financial capacity, they do want to make sure that a mentor doesn't have 2 proteges that are going to compete against each other, because they feel that that would arise, some sort of conflict of interest. So that would be a secondary concern as well.
Okay. One final question is, can you elaborate more on how the new Mentor-Protégé rules benefit a joint venture especially related to pursuing an SDVOSB opportunity. I did not think you can include a large company. Am I misunderstanding this?
I think I'm misunderstanding the question. Can you elaborate more on how the new mentor-protege rules benefit a JV? An SDVOSB can go after an SDVOS opportunity with a protege. That's part of the mentor-protege program. If I didn't quite understand the question, feel free to contact me after the webinar, and so I can give you more information. I'm sorry, I'm just not sure that I answered that fully.
Okay. Overall, I think the joint ventures and the ability to form the mentor-protege agreements with SBA approval and SBA expanding it to include all types of small business is immensely beneficial to the small business community and also especially our SECAF member community. And large businesses, because more and more work is going into the small business world, can also use this process to mentor smaller businesses and can benefit through this process if they are serious about willing to create those partnerships. And the joint venture capability looks like it's a great opportunity for small businesses to participate with other large businesses and take advantage of the new expanded rules and bid on new contracts and gain a lot of additional experience and capabilities that can help grow their firms. If they need to call you or reach out to you, would you like to give them your information, Devin?
Oh, I'd rather not. No, just kidding. It's on the presentation, I believe, so that there's my email, so people can feel free to send me an email. And I really do try to respond, and I apologize if I haven't gotten clearly what somebody's question is. Let me just mention there was another question that came in regarding foreign ownership and control and non-U.S. citizen board members. That's really outside the scope of this particular webinar, and that actually might be a better question for SECAF's contractor advisory forum, where those type of questions can be given to more experts on this particular topic.
That's great. I think we have a very robust contractor advisory forum also as part of SECAF, and thanks for recommending that to the Contractor Advisory Forum, Devin. I think that will be a huge benefit to our member companies too. With that, we have 2 more minutes, and we've had a very robust discussion on a very important topic for all the small business companies out there, and I hope that you all benefited from learning about the new expanded capabilities of the Small Business Mentor-Protégé program, and would work to take advantage of those. And if you need any questions answered further, please do send us an email, and you have Devin's contact. And I also hope that some of you who may not be a member of SECAF will definitely, as soon as we hang up here, will immediately log into www.secaf.org and fill out that application form. It is not very difficult to become a member. We want you to participate, and as more companies participate, everybody benefits. So with that, I want to thank Devin for a wonderful seminar, and for all that information, Devin. Thank you very much, and hope all of you have a wonderful day and continue to participate in SECAF webinars and other programs. Thank you.